We're always told to live and let live, but things don't seem to work out that way, do they? Take, for example, the transgender movement's insistence that everyone else ignore what is physically true and pander to their psychoses. Such is the situation with the case of Adams versus School Board of St. Johns County, Florida. Drew Adams is a minor girl pretending to be a boy. Even though the St. Johns County School Board has made accommodations for Ms. Adams' delusions, she's still not happy. She wants to use the boys' bathroom rather than the sex-neutral bathrooms that were specifically set aside for the very few confused students. She is so insistent that she, through her mother, sued the school district in federal court. This case made its way all the way to the 11th Circuit Court of Appeals, and we'll discuss that next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Englert here with the Constitution Study. This is where we read, we study the Constitution, teach a rising generation to be free, and I'm glad you could join me today as we're going to be talking about, well, bathrooms, but I promise, no bathroom humor. Things have been a bit crazy here at the Constitution Study lately. I've had a lot going on, several interviews and events and happenings. I was at the Reawaken America tour. I did lots of interviews. It was crazy, but I'm starting to get things back on track. I'll talk a bit more about that at the end of the episode, but for now, let's talk about Adams versus St. Johns County School Board. Why does it always seem that live and let live turns into my way or else? It happened with the same-sex marriage movement, and it's happening again with the transgender movement. The case of Drew Adams versus School Board of St. Johns County is a perfect example. This case involves the unremarkable and nearly universal practice of separating school bathrooms based on biological sex. This appeal requires us to determine whether separating the use of male and female bathrooms in the public school based on a student's biological sex violates either the Equal Protection Clause of the 14th Amendment or Title IX of the Education Amendments Act of 1972. Now, we hold that it does not. Separating school bathrooms based on biological sex passes constitutional muster and comports with Title IX. Let's start by getting some background on this case. Plaintiff appellee Drew Adams is a transgender boy. This means that Adams identifies as a male while Adams' biological sex, sex based on chromosomal structure and anatomy at birth, is female. Adams entered the school district in the 4th grade as a biological female and identified as a female. At the end of the 8th grade, however, Adams began identifying and living as a boy. Well, for example, Adams dressed in boys' clothing and wore a chest binder to flatten breast tissue. Most pertinently for this appeal, Adams adapted the male pronouns he and him and began using the male bathroom in public. So Drew is a girl who identifies as a boy. Have you heard the question, how many legs does a dog have if you count the tail as a leg? The answer is 4, because calling the tail a leg doesn't make it one. Calling a person with 2 X chromosomes a boy, dressing them like a boy, and giving them a boy's name does not make them a boy. In August 2015, Adams entered 9th grade in Alan D. Nease High School within the school district. Nease provides female, male, and sex-neutral bathrooms for its 2,450 students. The communal female bathrooms have stalls, and the communal male bathrooms have stalls and undivided urinals. In addition to performing bodily functions in the communal bathrooms, students engage in other activities like changing their clothes in those spaces. Single-stall, sex-neutral bathrooms are provided to accommodate any student, including the approximately 5 transgender students at Nease who prefer not to use the bathroom corresponding to their biological sex. The bathrooms at Nease are ordinarily unsupervised. The school board, like many others, maintains a long-standing, unwritten bathroom policy under which male students must use the male bathroom and female students must use the female bathroom. For the purpose of this policy, the school board distinguishes between boys and girls on the basis of biological sex, which the school board determines by referencing to various documents, including birth certificates, that students submit when they first enroll in the school district. The school board does not accept updates to student enrollment documents to conform with their gender identities. See, like every school I have ever been in, Nice High School has male and female bathrooms. The boys use the boys' room and the girls use the girls' room. Nice High School has gone the extra mile and created single-stall, sex-neutral bathrooms for those who do not want to use the single-sex bathrooms of their sex. This seems to me to be a perfectly reasonable compromise. Not between the school and transgender students, but between the non-transgender students and the transgender students. You don't have to look at ours, we don't have to look at yours. According to the school board, the bathroom policy addresses concerns about the privacy, safety, and welfare of students pursuant to the school board's duties under the governing Florida statute. In line with these concerns, the parties specified the following in their joint pretrial statement. The parties stipulate that certain parents of students and students in the St. Johns County School District object to a policy or practice that would allow students to use a bathroom that matches their gender identity as opposed to their sex assigned at birth. These individuals believe that such a practice would violate the bodily privacy rights of students and raise privacy, safety, and welfare concerns. Contrary to the parties quoted here, your sex isn't assigned at birth, but determined at conception. That's just basic biology. Both sides agree. There are students and parents who are not comfortable with people using the bathroom for the opposite sex. With all the focus on the confused transgender, it seems people forget that the vast majority of people are concerned for the rights and safety of those, especially the girls, who are often forced to share bathrooms and locker rooms with the opposite sex. Which brings us to this lawsuit. On June 28, 2017, after Adams' effort to change the school board's bathroom policy failed, Adams filed suit against the school board under 42 U.S.C. 1983, alleging that its bathroom policy violated both the Equal Protection Clause and Title IX. So after unsuccessfully trying to change the school policy, the Adams family tried to get the court to force the school district to not only ignore reality, but place the physical and emotional safety of the vast majority of their students under the control of a confused teenager. First, let's look at the question of a violation of the Equal Protection Clause from the 14th Amendment. The Equal Protection Clause provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. Now, the Equal Protection Clause is essentially a direction that all persons similarly situated should be treated alike, and simply keeps governmental decision makers from treating differently persons who are in all relevant respects alike. Does the school's bathroom policy deny Ms. Adams the equal protection of the law? For that to be true, you must believe the fiction that she became a boy simply by saying so. You must also ignore the fact that she has female anatomy and genetics. Quite the contrary, it is Ms. Adams who wishes to deny the equal protection of the law regarding single-sex bathrooms to everyone else. Thankfully, the court agreed. Adams claims to be similarly situated to biological boys in the school district for the purpose of the bathroom policy, even though Adams is not biologically male, the only characteristic on which the policy is based. Throughout the pendency of this case, Adams remained both biologically and anatomically identical to biological females, not males. Thus, in prohibiting Adams from using the male bathrooms, it can be argued that the school board did not treat differently persons who are in all relevant respects alike for purposes of the Equal Protection Clause. To argue otherwise, the dissent, like the district court, must assert that transgender status and gender identity are equivalent to biological sex. Indeed, this forms the foundation of the dissent's attempt to frame this case not as a case about the constitutionality and legality of separating bathrooms based on biological sex, but rather as a case about the purported unlawfulness of excluding Adams, who attended school as a biological female, from using the male bathroom because, as the dissent claims, Adams is a boy for the purpose of the bathroom policy. Now, what about the Title IX question? Title IX was passed as part of the Education Amendments of 1972 and patterned after the Civil Rights Act of 1964. The statute mandates that, subject to certain exceptions, no person in the United States shall, on the basis of sex, be excluded from participation in, denied the benefit of, or be subject to discrimination under any education program or activity receiving federal financial assistance. See, Title IX was created specifically to protect females in sports, to make sure they had a chance to compete against those of similar biology. have safe places to train, change, and yes, use the bathroom. Notwithstanding Title IX's general prohibition on sex discrimination, the statute provides an express carve-out with respect to living facilities. Nothing contained in Chapter 38 shall be construed to prohibit any educational institution receiving funds under this act from maintaining separate living facilities for the different sexes. Once again, we see it wasn't the school that was trying to violate Title IX, it was Ms. Adams. To interpret sex within the meaning of Title IX, we look to the ordinary meaning of the word when it was enacted in 1972. One of the methods of determining the ordinary meaning of a word is by looking at dictionaries in existence around the time of the enactment. Reputable dictionary definitions of sex from the time of Title IX's enactment show that when Congress prohibited discrimination on the basis of sex in education, it meant biological sex, i.e., discrimination between males and females. It truly takes some linguistic gymnastics to interpret sex in the meaning of Title IX to mean a mental disorder and an inability to recognize the basic facts of human biology. The Circuit Court looked at the decision from the district, along with the questions about the Equal Protection Clause in Title IX, and came to the quite reasonable conclusion that having single-sex bathrooms based on biology is not discriminatory. Personally, I would have gone a step farther and said that Ms. Adams' request was a truly discriminatory act here, since she wished to deny the 2,445 students in Nice High School the opportunity to use a single-sex bathroom in order to fulfill the delusions of the other 5. In fact, she wanted to effectively rewrite basic human biology to accommodate her delusion rather than comply with what I can only describe as a quite reasonable accommodation offered by the school: individual sex-neutral bathrooms. This lawsuit, which may not be over, is just the latest in the war against reason, morality, and common sense that has been sweeping across this nation. Some may be offended by me referring to the plaintiff as Ms. Adams. All I can say is the most caring thing I can do for Ms. Adams is not to enable her in her delusion. If she wants to dress like a boy, I won't stop her. But when she expects the world to warp around her delusion, she needs mental help. Now, whether this case is over or not, there are bound to be more cases, not to mention more situations, where the deluded attempt to impose their delusions on others. I can only hope that some sanity will appear in the American people on both sides of this debate can learn to live and let live. I know a lot of people get wrapped around the axle about the fact that I don't use preferred pronouns. I use accurate English pronouns. I use things like Ms., not Mr., to represent a young girl because she looks like a boy or dresses like a boy. This idea that reality will change because we want to, it truly is a mental psychosis running rampant through our nation. To me, the sad part isn't that Miss Adams is confused. That's bad enough. But how many adults have reinforced her psychosis to the point where she's willing to go to federal court and claim that just because she wears boys' clothes, wants to use a boy's name, and asks to be used boys' pronouns, suddenly her biology changes? It's irrational. But that's the state of affairs in America today. And until some of us start standing up and saying, no, I'm sorry, that emperor has no clothes, it's going to continue. And it's going to get worse. The question is, will those deluded people, the poor psychotic people who can't look in their pants and determine if they're a boy or a girl, who think that just because they think something, it must be so, will they get the help they need before they turn this country inside out? Things are not looking good. But there is hope. Because people like you will hopefully watch this video, listen to the podcast, read the article, and have the fodder to simply say, no, I'm sorry, you're not a boy, you're a girl. You want to change your name, you want to wear boys' clothes, fine, I'm not going to stop you. But if you're going to tell me I must ignore reality to feed your psychoses, well, what happens when your psychoses contradicts with their psychoses? Now which one do I support? It's crazy. But if we get together, we stand up and politely and lovingly say, I'm sorry, you're wrong, and I'm not going to feed your delusion, we'll get yelled at, we'll get called names, but maybe we'll show people that there is a place of sanity in this world of confusion. So I hope you like this episode. Hey, head over to the website, constitutionstudy.com, find the article, find the other things supporting this, and spread the word. Let other people know they also can hear the Constitution study. They find the podcast, they can find the videos, they can read the articles. Hey, maybe sign up for one of the mailing lists. You can have these articles and these videos delivered to your email as soon as they're published. Most of all, spread the word on social media. I'm trying to do some things to get more social media engagement. I'm trying to do some short videos. I'm doing some more meme type stuff to try and get tools that you can use to help you share and help the word spread about the Constitution study. Most of all, I hope you'll come back and visit. Maybe even bring a friend or two as we join here together to read and study the Constitution right here on the Constitution study.